All right. Good afternoon. Call to order this Fairfield Plan and Zoning Commission special meeting for Thursday, May 22nd. Jump into our one and only item for executive session. Uh, 2179, 2199 Post Road, 29 Fairfield Place, zoning compliance and coastal site plan application of Sunshine Development LLC pertaining to a 60-unit residential development pursuant to Section 830G of the Connecticut General Statutes. Ms. Harrigan, I think you have some staff comments for us on this.
I do. Thank you, Mr. Chair. The subject property, as the chair described it, is an aggregation of 3 existing parcels and totals approximately 31,000 square feet or 0.71 acres, and is presently entirely within the Design Commercial District DCD. However, it was rezoned as a Center Design District property via a separate application, and currently that application is under appeal. The property is bounded by Post Road to the north, Lindbergh Street and a residential home to the east, Fairfield Place to the west, and 2 residential properties to the south. The proposal includes a 5-story, 60-unit residential building with a level of subterranean parking proposed under the 830G statute. It should be noted that both the DCD and CDC zones otherwise require a commercial ground floor component within a proposed development. 55 of the units are provided as 1-bedrooms, and 5 units are studios. 3 units are provided as ADA wheelchair compliant. The overall height for the building is 62 feet 3 inches. Total parking provided is 71 spaces, which is a ratio of 1.18 spaces per unit. The building contains amenity meeting space, a fitness gym, clubhouse, outdoor lounge, garden area, and a rooftop pool and landscape deck area. Some of the common amenity spaces are oriented towards the Post Road, including 2 small public plaza areas at each corner of the building. There's a ground level green space area towards the rear of the property, which is accessible via a walking path that integrates into the public sidewalk provided at the street frontages to provide circulation around the site. Street trees are provided on all street frontages with a landscaped area to the rear of the building. Street trees are provided, oops, sorry, lost my place. To the rear of the building on both Fairfield Place and Lindbergh Street. Per the 830G statute, 30% of the units or 18 units will be provided as affordable, with 9 at 60% of the area median income and 9 at 80% AMI. Driveway access and site entry is one directional off Lindbergh Street and one-way exiting out of Fairfield Place. The applicant's experts have indicated that WPCA approval has been granted for this project to connect into the town sewer system, and public water supply is available at the site. The stormwater system has been designed to accommodate the 1-year storm event and is the same as the system from the prior mixed-use proposal. The town engineer requested clarification of the soils conditions with observed test pits where they observe favorable soils that are consistent with the applicant's proposed stormwater design and analysis and town engineering requirements. Proposed building lot coverage is 75.94%, which is close to the 75% required in the DCD zone and within the 90% allowed by the CDD. The applicant's traffic consultant's report indicates that the trip generation for the proposed 60-unit building can be accommodated by the Post Road State Route 1, and driveway sightlines exceed the minimum required for the project, provided that a 15-foot no parking zone is noticed and enforced from the driveway exit area. Staff recommends that the commission require that the applicant request this change to the right-of-way through the local traffic authority. The proposed building provides a full interior sprinkler system. Although this site is located within the coastal site plan review area, there are no coastal resources in the close proximity of the site. The DEP coastal planner requests a condition that sediment and erosion controls are required prior to the start of any construction-related activities and must remain in place for the duration of the construction project. The property is not located within a FEMA flood zone. Neighbor testimony expressed concerns about safety due to narrowness of the roadways on Lindbergh Street and Fairfield Place, combined with the lack of sidewalk and their expectation that the proposal does not provide adequate parking and additional on-street parking spaces will be added to their neighborhood. Other residents also expressed concern that the project might negatively contribute to the post road traffic, which could lead to additional cut-through traffic in their neighborhood. Attorney Green, representing an adjacent neighbor at Lindbergh Place, provided expert testimony via written comments indicating concerns with the traffic analysis and the stormwater design. The applicant's rebuttal included their experts clarifying the questions raised about traffic and stormwater design via written comment. As a reminder, due to the similarity of the traffic impacts and the same stormwater design, the applicant has requested that the full record for the prior mixed-use application at this address be incorporated as part of this record, which includes information from both Attorney Fallon, representing the applicant, and Attorney Green, representing adjacent neighbors. The commission is familiar with the standards for review of a denial of an affordable housing application, and those standards were discussed during the hearing. The burden shall be on the commission to prove that the decision is based on sufficient evidence in the record. The decision is necessary to protect a public interest in health, safety, or other matters within the commission's jurisdiction. Such interests clearly outweigh the need for affordable housing, and such public interests cannot be protected by reasonable changes to the proposed development. Court cases have indicated that the record must establish more than a mere possibility of harm to a substantial public interest. The record must contain evidence as to a quantifiable probability that a specific harm will result if the application is granted. Mere concerns alone do not amount to sufficient evidence to support the denial of an affordable housing application. And that's all I have, Mr. Chair.
Thank you, Ms. Harrigan. Tom, last we had this, you had made a motion, then was courteous enough to withdraw. Do you want to start again, or should I open it up?
Yeah, I'm happy to.
Excuse me one sec. Someone messaged me? Sorry, they can't get into the room. I don't know if there's anyone in the waiting room. Sorry, Tom.
No problem.
Okay.
Yep.
Message you personally? Alexis, texted you personally or sent a chat?
Sent a chat. Not me. It's not anyone related to this. It's just a member of the public.
Okay. This isn't closed, right? We should be open.
No, it's not a closed meeting. So I would recommend that they go out and go back in. It's not a locked meeting, so anybody can enter. And I
Right,
don't.
But it's not currently locked either. Is my question my question?
Correct. No, because it's an open public meeting.
All right, and I think I saw a few people that were. I mean, I see some members of the public.
Yeah.
I see Attorney Green. So other people have gotten in. All right. Commissioner Corsillo.
Thank you. Okay, I will restate my motion from last time.
Commissioner Braun, we got some feedback from your end. Can you go on mute, please?
Okay. Is that okay?
I'll see in a second. Go ahead, Commissioner Corsillo.
Move to approve with the following conditions. That the applicant add inverts to the proposed trench drains to the satisfaction of the town engineering department. That the applicant add a trench drain at the terminus of the drainage pipe toward Fairfield Place. That the applicant design pipe routing and shallow drain connections within the roof deck ceiling structure to the satisfaction of the engineering department. That the applicant maintain adequate sedimentation and erosion controls during construction per DEP recommendation. That the applicant add a clay barrier along the property line to the south to contain infiltrated water per town engineering department recommendation. And that the applicant requests that the local traffic authority create and enforce a 15-foot no parking zone around the exit driveway.
I'll second.
All right, second, Commissioner Levy. Commissioner Corsillo, go ahead.
Thank you. So while this application is independent from the mixed use application. Evidence from the previously approved application for the site was made part of the public record for this application. And I note that because this commission approved the previous application. And as I said, when we reviewed that prior application, I felt at the time the neighbors certainly had demonstrated that the surrounding streets are presently unsafe for pedestrians. But particularly in an 830G application, an existing condition is not a grounds for denial. The current application is 100% residential and will therefore have less of a traffic impact than the prior application, even despite the greater number of residential units. And given that the evidence from and approval of the prior application are part of the evidentiary record of this application, I don't believe this commission could find that traffic concerns, at least those of us who found in favor of the prior application, could find that traffic concerns are grounds for denial. Stormwater concerns, the other primary objection to the application, I believe are addressed through reasonable accommodation, as stated in the conditions for approval. The objections raised by the opponent's expert focused on the assertion that aspects of the stormwater management plan do not meet the 2024 DEP stormwater manual requirements. There was, of course, some debate over that, with the applicant expert countering that it does in fact meet those requirements. However, I don't find the evidence in the record demonstrates a quantifiable probability of harm to the public health or safety, given that the DEP stormwater manual requirements aside, it does appear to meet the town's requirements, or the requirements that the town currently uses. The one other consideration I think is worth mentioning, one or two commissioners, I believe, has raised the what I think we've been calling the tipping point argument, as relates to the presence of commercial or the lack of commercial in this application, given its location on Post Road, obviously an important commercial corridor for the town. My personal interpretation of the state statute is that commercial cannot be considered as a reasonable accommodation. But regarding the tipping point argument, while I think development along Post Road, including on this site, should be mixed use, I think I certainly prefer the mixed use proposal to this. I'm not persuaded that we've reached the tipping point yet in terms of the loss of commercial space that could give us grounds to deny an application anywhere along Post Road. But further, this particular site is not in the core of our downtown. And so even if we were closer to what I thought was the tipping point, I don't think it would be grounds for denial on this site. It's a thus far underutilized end of the downtown, such that I don't believe the potential loss of a commercial space there is as detrimental to the town as would be a commercial property, let's say in the downtown core around the community theater. So again, I will beyond that refer to my previous comments with regards to the prior application, which are all part of the public record. I do not believe the claims raised by the opponent meet the required standard for denial of an 830G application, and therefore will be voting to approve this.
Thank you. Commissioner Levy?
Thank you.
Ron?
Yeah, I share in Commissioner Carcillo's comments. Again, I don't find there's sufficient evidence to show a likely or probability of a substantial threat to a public interest in health and safety, which would outweigh the need for affordable housing. I do note that in addition, there was a considerable amount of testimony about the stormwater system and whether it was adequate, and particularly with respect to its potential for nitrogen and phosphorus pollutants to bypass the system. And I did check the 2024 stormwater manual, and in fact, it does, as the applicant's expert suggests, when you meet the 80% standard for retention, in fact, it is not necessary to calculate individual pollutant amounts. So that does rebut the claim of a substantial threat of an environmental harm here. In addition, I also do note that the evidence, in fact, from our town engineer was that the system and the soil tests confirmed that this system would be adequate. So based upon all of those, I will be voting in favor of this application. Thank you.
Thank you. Other comments from the commission? It's hard to see people, so you're just going to have to kind of speak up.
Yeah, it's Peter.
Go ahead,
Collins.
Commissioner Collins.
Yeah, I'm obviously very concerned with the additional congestion of traffic. It is, people might have a misconception that commercial structures and commercial entities such as a nail salon, a restaurant, whatever, it's somewhat of a temporary traffic problem, whereas residential, these are permanent traffic problems in an already very traffic heavy area. The cut through, which I've actually used myself because sometimes the traffic is at such a standstill. The car, each family that might house in these units most of them have more than one car and are permanently fixed there, and will be part of just an ever increasing traffic congestion problem. And I think some of the fellow commissioners could probably go further onto the stormwater and the problem of having possible toxic phosphorus and nitrogen draining into our groundwater. I think the town has been has had its share of problems with with the fill pile debacle that we went through, which is probably still millions of dollars and counting to remediate that problem. So I would really be concerned with that. And the traffic is just unbearable at certain times of the day and odd times of the day even. I drive that area all the time. I see it getting worse and worse, and I would vote to not approve this. Thank you.
Thank you, Commissioner.
I'll speak if
Go
anyone
ahead.
else wants to.
Go ahead.
Can you hear me?
Yes, we can hear you.
Okay.
Thank you.
It's Alexis. Yeah. I will be voting against this. Just looking back the last few days through the materials, the neighbors hired experts to talk about stormwater and traffic. And I think there are significant issues related to public health and safety with this. I think it already confirms what we already know, which is our downtown is increasingly subject to flooding. Traffic congestion has increased over the years. I don't live far away. I live about maybe a mile away from this area, and I drive through that very often, and the traffic is horrendous. I can't even imagine another 60, 120 cars would do. Putting a project this size with 60 units on a very small parcel of land where one side faces an extremely congested traffic area and the other side borders two very quaint residential neighborhoods, the very narrow streets and no sidewalks, I think is recipe for a disaster. I personally can't participate in approving this project because I know it will cause the public health and public safety issue at one point in time. I would also agree with the opposition's experts that the stormwater system is completely inadequate. It's not far from the portion of the Mill River, which is part of the harbor and tidally influenced. And I don't think in good conscience this board should approve a project that could send dirty stormwater into Long Island Sound. Again, that would create a massive health issue. So for those reasons, I will be voting against. Thank you.
Thank you.
I have a comment.
Go ahead, Commissioner Braun.
Okay, I'm going to read from what I typed up on the same phone I'm talking from, so hopefully this works. On stormwater, I have several points. The testing was still not the proper test according to the 2024 stormwater manual. It was basically a deep perk test and not a proper bore infiltrator test according to Mr. Steve Trinko, who I take as more credible than the others based on his 25-page CV, where he is an actual long-time expert on low-impact LID development and stormwater systems. And he's lectured over broad and he's won awards and things like that. So he told us it was not done the right way based on what we heard on how it was done. He was also not invited to participate. There's no legal obligation to invite him. But once you have 6 months ago, the prior expert by the neighbors said we needed this test. And I believe even Mr. Hurley said we needed more test pits back then. And now we have this application where we closed it to public comment. And then we have a test done without even the courtesy of inviting the expert that said we need the test, either of the experts. And if he had been there, he would have been able to observe whether it was done the proper way. He said it wasn't done the proper way. He said the level of okay, I'm not an expert, but because they found that it's going through very, very fast, it's too fast to even be logically appropriate. And when you do a test pit and stick a pipe in the bottom, you're changing the sort of density of the soil and you're not reflecting reality. And the results did not make sense. So we don't have good results. So it either could go through too fast or too slow. Either way, it's not going to work. Aside from that, let me just continue on. So what they found was extremely loose soil, which would then not properly cleanse the dissolved toxins. They would just flow through without being cleansed, such as nitrogen and phosphorus. He also pointed out there's not enough land on this 0.71 acre parcel, which is almost paved over, based on the design of this development to enable the biofiltration which is needed to eliminate the dissolved toxins before they enter the groundwater or the coastal area, which this is very close to. Also, civil engineers are required to act in the interest of public health and safety. That may at times cause them to go beyond what a town requires or even what the stormwater manual requires. It's a site-specific, project-specific review. That's why we're here. That's why they're giving a presentation, not to look at whether you check the boxes in a guideline. We can go beyond that, and we need to go beyond that if the site and the project requires that. Number 5, the system must be designed fully with enough data and detail to prove to our commission that it will work. We do not leave design considerations for the town engineer to work out later on when it goes to the building department for a building permit. This is our job. Now, in the Hurley memo, he said, we haven't seen revised plans or calculations. This may result in a larger detention infiltration unit and perhaps a larger separation distance. It's all very speculative. We don't have confirmation on what the design will be or if it will work or if there's space within this project, which has the same footprint as the prior project, for it to work, for proper low impact development LID solutions to even work, if they tried to do that, which they're not. Number 6, the town engineer and the applicant consultant met without notifying the intervening party, which is, I'm sorry, they're not an intervening party, but it would have been proper to do so, especially given that this was done after we closed public comment. Basically on rebuttal, you're providing new tests. I believe that was a procedural violation anyway. Because neither the applicant nor the town engineer chose to notify or allow participation or observation by the other expert, the opposition's expert, and it was done after the hearing was closed, I don't even think we should consider it, especially given Mr. Trinkhaus's testimony that his opinion is it was not done the proper way to give us the information we need to determine that this will work. And that's the bottom line. It has to work. And so it behooves us to do our job to make sure this will not cause any harm to the public health or safety or to the environment, which is one of our valid considerations under 8-30G. These were tests, as I said, that were determined to be missing on the prior application, which now has been incorporated into this application 6 months ago, and it shouldn't have taken this long to do those tests, especially without notifying the 2 experts that said we need the test. Dissolved toxins just move through the soil. They don't get treated. Nitrogen is only cleansed in a wet system, anaerobic. It will end up in the groundwater in Long Island Sound. This is not a wet system. Nutrients such as phosphorus and nitrogen are best removed through the vegetative process, biofiltration. You need more land to do that. It's not going to be possible here. Nothing that's proposed on this site plan removes nitrogen in its soluble form. Therefore, it will pollute the groundwater. It does not go away. Phosphorus might adhere if there's enough silt, but again, the test wasn't done right. We don't know. Continue on. So the system cannot be shown to work because the proper testing was not done. There's not enough land to cleanse the dissolved toxins before they reach groundwater. And then the tidal portion of Mill River, which is below the post road, which is literally, I don't know, 500 or 600 feet away from Southport Harbor, which begins at the Tide Mill Road there. Regarding traffic, I'll just have a few points to supplement. The vision, okay, well, not really traffic, but the vision. The vision was to do the prior application that this commission approved. This was not really a change. All they did was add a floor, take out the commercial. Everything else is the same. It's basically a retread, same footprint, same drainage system, just add 10 feet higher, add 20 residential units. I don't think a lot of thought was put into this. The design is just avant-garde modern, which doesn't fit in. I know that's not our consideration, but it kind of shows what little thought went into this new project, which they admit is a backup plan. In case they lose the appeal on the other one, they have this one to fall back on. That's not adequate for our commission to consider as good planning. Regarding parking, it's inadequate. It's short, according to the opposition's experts, by around 15 in the evening and around the same amount in the morning. You could have as many as 120 cars needing to park with overflow onto these little side streets. I think people will have cars. This is 0.7 miles away from the train station and 1.7 miles away from Stop and Shop. They only have 75 spaces on site, and they pretty much admit that's not enough because they're trying to create 7 new ones on the post road. And also they need to block off part of the post road so they have, I guess, line of sight leaving those roads so people don't park along the post road. Rural Britannia will lose their parking that they have on this site now. And between the overflow from Rural Britannia on Fairfield Place and the overflow from this site, it will fill those little side streets, which are filled with children playing. I've been down there a number of times. The demand is understated for parking at both the peak hours. And the other commissioners mentioned there's no sidewalks, poor lighting, children play on the street. Only 1 space is allotted for loading, for commercial delivery, you know, Uber, Amazon, all that, food deliveries. That's not going to be enough for 60 units. And then those delivery and moving vans will park on the street, most likely. Trip generation data was largely generated in the ITE before the pandemic. It does not account for these added services. The crash report, which was updated, indicates that 82 crashes took place in the last 6 years with 1 fatality. That averages to 13 crashes a year in this neighborhood. You will have, with more development, not just from this, but other more development, increasing cut-throughs and increasing congestion. And with people parking willy-nilly everywhere, you're going to have more crashes. That's clear. So everything that we learned from the opposition's traffic and stormwater experts indicate that this will provide a specific quantifiable harm to public health, safety, and environmental concerns. And it must be denied. I know the applicant wants a unanimous decision, and I'm hoping it will be unanimous for denial. Thank you.
Thank you. Commissioner Randolph, you or me? You're on mute.
Go ahead.
Okay, I will be, excuse me?
I'll be quick. Go ahead.
No, if you're quick, go ahead.
Oh, sure. As a reminder, the burden of proof under 830G is high. Denial must be based on substantial evidence of harm that clearly outweighs the need for affordable housing. But in this instance, that threshold has not been met. I'll be approving this application. The application meets the requirements for approval under 830G. The applicant has secured approvals to connect to the sewer system and public water is available. The proposed stormwater system, consistent with the design previously found, is acceptable for the site and has been reviewed by the town engineer, who offered preliminary approval. Minor clarifications are expected at the building permit stage. Town engineer is the qualified authority for this technical determination. Lot coverage complies with the DCD zone and is below the permitted in the underlying CDD district. While traffic on the post road is a growing concern, the applicant's traffic study concluded using ITE standards, which are frequently questioned, but they've been adopted by CTDOT, the US DOT, and the traffic evaluation, and it's the traffic evaluation standards adopted in all 50 states. I do have a proposed text amendment to make this part of our ordinance as well, but it is, ITE is recognized in all 50 states and CTDOT, and it states that the 60-unit development can be accommodated. Sightlines meet or exceed required standards with a 15-foot no parking zone, and the opposing traffic study did not provide persuasive evidence to the contrary. Although the site lies within the coastal site plan review area, it contains no coastal resources. I just want to emphasize that. We keep talking about the impact of coastal resources, but DEEP said it did not impact coastal resources. DEEP made that determination. It's also outside the FEMA designated flood zones. Issues have been raised about the project's impact, but DEEP determined that standard erosion controls, and this is what's been debated, but DEEP determined this, not our readings of this, but DEEP said that standard erosion controls are sufficient and have been met. And Commissioner Corsillo added some that will be conditions of this approval. Neighbors raised sincere concerns, and I do share these concerns about traffic, parking, and pedestrian safety. These concerns are acknowledged. However, no quantifiable public risks sufficient to justify denial have been demonstrated. And as a member of the local traffic authority, I'm committed to prioritizing corrections of this. The record supports approval with reasonable conditions to address the specific site impacts. That's all I have.
Thank you. I too will be supporting the application. I find the applicant's testimony and evidence and their experts to be the more credible, the more weighty. For that reason, I would believe that the application should be approved. I don't believe that the increased traffic is going to what is currently there will cause a substantial harm. I believe there's sufficient parking. That is, the ratio of parking is in line with the other 830G applications that we've seen throughout town. And to my knowledge, and as I understand from staff, their knowledge has not been any complaints about. As to engineering, I again find the applicant to be the more credible expert, but more importantly, I'm relying upon the town engineer in making the initial approval, and then we'll be making approvals after the fact. To that end, I think we need all to remember is what our role is as this commission. We do not have this broad inherent authority that is exceptionally broad and over-encompassing. As we've been told by the Connecticut Supreme Court and courts in general, we're a limited body, limited jurisdiction. We were one of the issues that the Supreme Court upheld or ruled against us in the Beach Street was our using sightline analysis for denying that application. And the Supreme Court was pretty clear that since we did not have any standards in our regulations, we really couldn't be using that kind of a standard we were being arbitrary and capricious, I believe it was, because we did not have a standard that was set out in our regulations or our ordinances to follow. And that it leads to a problem, I think, when we're dealing with the conflict, these battle of the experts for the engineer. Here we have the opposition's engineer using an advisory document, the 2024 stormwater deep, that it appears that, well, we certainly don't have in our regulations, or ordinances, as far as adopting and utilizing them, and that the town engineer does not use fully in his work. So and as Commissioner Levy pointed out, it seems like, and even the applicant's expert pointed out, there seems to be some picking and choosing as to what is being utilized and relied upon, and not following it through to completely as to what it's outlined. So which adds to a credibility issue in my mind. So we have to be mindful of what standards we're using when we are determining what is the health and safety, and we have to be following the law as laid out by the Connecticut Supreme Court and other courts, but at least the Connecticut Supreme Court, because even that I think it was Beach Road, where we were using sightline distances, and that was a pretty standard thing to be using. And I think even in the industry, sightlines as to what's standard. And the court said that without something more in our regulations, we couldn't really use that. So I would be mindful of the fact that we have to have sufficient bases for our decisions that are rooted in our regulatory authority, and is within our regulations as well. So for all those reasons, as I said, I find the experts, the applicant's experts to be more credible experts and standards that we are able to utilize or allowed to utilize, or just in general, and the town engineer as well, and believe that this application should be approved.
Can I make a short comment?
Go ahead, Commissioner Braun.
Okay. So I keep hearing that everything we get from other advisory entities, such as the town engineer or the building department or DEP, that takes away our job. It doesn't take away our job. They're advisory to us, and we are the final regulatory authority on protecting our coastal resources and protecting our constituents, our town residents, from traffic, health, safety hazards, as well as environmental hazards. So that's our job. We are not potted plant sitting here saying, oh, you're going to do this later so we can approve it. My recollection of Beach Road is there was a lot of discussion over whether we can approve it subject to the police later on getting rid of cars parked on the road, or whether we can consider cars parked on the road as part of sightline analysis. I think every application rises and falls on its own facts. This is a different neighborhood. We know about the cut-throughs. We know about the overflow parking on the roads now. We know about the narrowness of the roads. We know about the children playing on the road. A lot of those facts do not exist on Beach Road. They exist here. That's why we do a public hearing with testimony, with experts, and we make those decisions based on this neighborhood and this impact on this neighborhood. So I don't think we can fluff it off and say, Deep did something, so we have to accommodate what Deep said. No, Deep didn't even go to the site. They don't know exactly what's going on here. I doubt they seriously investigated. They certainly didn't do a peer review, and I don't think engineering did a peer review. So based on all of that, we can choose which experts we want to believe. I picked the one that had a 25-page CV that is internationally, expert on low impact development techniques, which is not being done here. Thank you.
Thank you. And again, as I said, I think the people in support of the application chose the other experts as far as specific. But again, I think the Connecticut Supreme Court, and I'll reread the decision on the sightline stuff, had nothing to do with the circumstances of the application, but just in general, us being a limited body that does have a say in certain matters like this needs to have recognized standards in order to do it. And I don't believe the 2024 advisory stormwater management has not been adopted by us, not being used by our town, and that the opposition's expert relied heavily on that. And I think, as Commissioner Levy noted, at least in one instance, and I think in a few others, picked and choose when he should have. So, your point's taken, Commissioner Braun, but I think we have to have standards in order to make these determinations. And I think, like I said, we don't have that in here as far as adopting the 2024 storm management. And, again, I side with the applicant and the town engineer.
Okay, we'll have to agree to disagree on that one. Thanks.
Thank you. Anything further?
No.
All right, can we put this to a vote? It's good. I'm going to need people to say, to be verbal instead of using hands. All those in favor, please say aye.
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 And I think Commissioner Levy is an aye. You're on
He's
mute.
muted. He's
Aye.
Yeah, all right. So the Commissioners Noonan, Levy, Randolph, and Corsillo are voting in the affirmative. All those opposed, please say aye.
Aye. Harrison.
Aye.
Commissioner Harrison, Braun, and Collins.
Ron, I'd say aye,
Yeah.
I'm opposed.
Yep. Those three in the negative, so motion passes.
Thank you.
Thank you, everybody, for accommodating this on lunch on a Thursday. That being our last item, I'll adjourn the meeting.
Yeah, I appreciate the extra time. Thank you.
You're welcome.
Thanks.
Take care, everyone.
thank you.